Good morning, everyone. This is Bruce Davis from Findley Davies. We appreciate your participation this morning on this WebEx as we talk further about complying with the Affordable Care Act. This morning I'm joined by two familiar colleagues by now. Scott Newsom from Shumaker, Loop, and Kendrick is here, as well as one of my partners, Scott Hamner, who heads up our technical resources group at Findley Davies. But we're joined by a newcomer to you, Carrie Alexander, who is one of our senior consultants in our change management communications practice, is joining us because we'll be talking a little bit about some new communications-related healthcare reform activities a little later. We're coming to you from the Findley Davies Toledo, Ohio office this morning. So again, thanks for participating. There is a chat feature that you are probably familiar with. We did this a similar presentation yesterday, and it seemed to work well. That as we were speaking, people were submitting their questions via this chat line, and we were able to address those questions as we went along. So we'd like to do that today as we go through this. If something occurs to you and you want to ask a question, go ahead and please do that. You can click on that chat button, type in your question, and send it to us, and we'll see it on our screen. You won't see it on yours, but we'll see it on ours. But we, as we did with our last call, when we put an FAQ together after that last WebEx, we plan to do the same thing today. So if we don't address all the questions that are submitted today, we'll do another FAQ and have that posted on our website. So going into the agenda, we are going to kind of give you an update on the employer shared responsibility rules. We did not, since we only have an hour with you today, we felt we don't want to cover a lot of the ground that we have spoken about in the earlier WebEx presentations. We're going to try to focus on what is either new or discuss some of the questions that we're getting from clients and other friends of the firm. And so there's going to be a section in this presentation that we're going to call special considerations. And it basically relates to questions that have come up about, well, what do you do with part-time salaried employers? Or what do you do with teachers or substitute teachers? Or what do you do with PRN nurses that work with hospitals and so forth? So we're going to get into that in the body of the presentation. And then Carrie is going to help address the notice that the HHS released on May 8th. This will be the notice that you will be required to give to all your employees about the availability of a health insurance exchange or marketplace. And so we'll be covering that as well. So kind of jumping into this, talking about the employer shared responsibility rules. We're not going to go over this chart in detail. Again, you will have it. You've seen this before. You'll probably be wanting to refer to this as we talk through the employer shared responsibility rules. I think a lot of the questions that we have gotten over the last few weeks, again, centers around what is an applicable large employer, and people ask a lot of questions about how to comply with that section of the rules. And so with that, I'm going to turn it over to Scott Newsom, and he will kick it off.
Okay. Well, thanks, Bruce. Again, just to orient you, all the employer shared responsibility rules apply to applicable large employers, and we just wanted to make a couple quick clarifying points to address some questions we've been getting. Applicable large employer status is determined on a calendar year basis, and it is determined the previous calendar year. So for 2015, you're going to determine whether or not your organization has 50 or more equivalent full-time employees in 2014. There's a small wrinkle, though, with 2013. You are allowed to pick any 6-month continuous period to determine applicable large employer status for 2014. So if we've had some employers that have been looking at their data, looking at the first 6 months, last 6 months, somewhere in between, trying to see if they can find a more advantageous situation where they're not an applicable large employer and can delay maybe a year of complying with these rules. One other quick point, you see on the slide there that we have the reference to aggregation rules. We've had some questions about, well, if common ownership is an issue, why don't I just transfer a portion of my ownership in one of these organizations to my spouse, to my adult children? There are also attribution rules between family members and some common owners that you need to be aware of. So if you're going to be trying to do some corporate restructuring, that's something that you need to really dig into the Internal Revenue Code with someone who knows what they're doing. And Scott?
Next point, and you said in an earlier session, we've gone over this before, but who is the employer? With respect to this 4980H tax, the issue, who is the employer of that particular individual? And the reason we bring this up is most of us, it's pretty easy. We work for a particular organization. We don't even think about it. But employer is really a fact set issue. It's who's controlling the work of the individual, setting the times of performance, setting deadlines, managing, et cetera, et cetera. There's a series of attributes to employee-employer relationship. This issue's been around for a long time in other contexts. So the healthcare related issue is just another subset of that. Who is the employer? And it is brought up, and the reason we discuss it here is because as employers consider how do they avoid application of 4980H tax, how do they avoid providing health care coverage, one of the ideas has been, well, what if I get rid of my employees, put them out to an employee leasing organization and then just lease them back? Well, there's two issues there. I mean, really, if they've been on your payroll forever, and then, the day after you go through this leasing organization, they're doing the same thing, really factually, I think the right answer is they're still your employees, and all you've done is engage an outside organization to write the paycheck. So you've got to be aware of trying to avoid, abusive situations. If it's too good to be true, it probably is not true. So with that, let's go to the next slide.
Okay. Lisa's going to go back to this schematic, and again, just a kind of a refresher. Assuming that you are an applicable large employer, if you look at the green boxes up at the top, and we're moving from left to right, assuming you are a large employer, does your organization offer, and the key word there is offer, minimum essential coverage to at least 95% of your employees and their dependents? Now, we don't have a lot of time to go over a lot of that again, but you remember that dependents does not include spouses as an example. So assuming that you have or you are going to be offering minimum essential coverage to at least 95% of your employees, the next test as you go to the right is, does at least one of the plans that you're offering meet the minimum value test? And you remember, as we discussed in earlier WebEx presentations, the minimum value test is, does the plan cover at least 60% of allowable charges? And if it does, then the next box to the right is, well, this is the affordability test. Do the contributions that you're charging for single full-time employee only coverage, do those contributions exceed 9.5% of their household income? That was what the Affordable Care Act provided for, and you'll recall in the earlier presentations, the IRS provided an initial safe harbor, recognizing that you as employers don't know what the employee's household income, you don't know what the spouse earns, as an example, that the safe harbor would be 9.5% of their W-2 Box 1 wages. Since then, as we'll talk a little later, they've given us a couple of other safe harbors on rate of pay and federal poverty line. But we want to make a couple of comments about passing the minimum value test, and then we'll get into the affordability test. The IRS has now explained that here are three ways that you can pass that minimum value test. Number one, you can use their minimum value calculator. The Health and Human Services has provided a minimum value calculator. Some of our clients have downloaded this themselves. They've plugged in their benefit specifications, and it spits out a value. They can see to what extent their plan measures up against that 60% of allowable charges. It's relatively easy to use. You can also use a safe harbor plan that's being developed by Health and Human Services. In some of their comments, they're indicating that they're contemplating offering you 3 safe harbor plan designs. They've mentioned one being a $3,500 integrated medical prescription drug deductible, 80% in-network co-insurance, $6,000 maximum annual maximum out-of-pocket maximum. So that's a second way. Or the third is to provide actuarial certification that they envision being used for non-standard plans. An example of that, one of our clients has an annual out-of-pocket maximum feature that's based on the employee's earnings. So for network, it's 6%. For non-network, it's 9% of their annual earnings. That's probably an example of where you would ask your actuary to provide an attestation that that plan meets minimum value. There's been some other things that have come up recently as to what do you count or apply towards that minimum value threshold. One question was if I have a high deductible health plan and with a health savings account HSA feature, and I as the employer am making contributions to that HSA, do I count those HSA contributions for purposes of meeting the 60% minimum value? And the answer is yes. Well, what's the case then if I have a high deductible plan with an HRA, a health reimbursement arrangement? Do I count my employer contributions for purposes of satisfying the minimum value? And the answer is yes, so long as that those HRA contributions are being used to reduce the employee's cost sharing for covered medical expenses. For example, the HRA is being used to pay for deductibles or co-insurance or things of that sort. The HHS has said that if that HRA were to be used for paying premiums, as an example, they would not allow you to count the HRA contribution towards meeting the minimum value threshold. So then you get into some of these other nuances about, well, we have cost-sharing reductions for non-tobacco users. We have a wellness program. We believe it's HIPAA compliant, and if you are a non-tobacco user, you will have a reduction in your deductible, as an example. Or conversely, smokers have a higher deductible. Can we consider that reduced deductible, that cost-sharing reduction for non-tobacco users, can we include that in our minimum value calculations? And the answer is yes. Well, what about other cost-sharing reductions for other non-tobacco related wellness programs? And here the IRS and HHS made a strange ruling, I guess, in my view. They said you can do that, you can count that reduction in 2014 only, but in 2015 you cannot. And Scott Newsom and I have been talking about this as to why they would have bifurcated the treatment of tobacco use wellness programs versus others. Scott, what's your thought about that?
Well, just one quick point. For 2014, in order to have that safe harbor for wellness programs that are on a health factor other than tobacco, say it's cholesterol, body mass index, whatever, that had to be in effect and on May 3rd, so that transition rule is only available to existing wellness programs. But yeah, as Bruce and I have talked, this really kills a lot of the usefulness of wellness programs based on a health factor such as cholesterol in comparison to tobacco. So if you're a smoker, get ready for some much larger premiums, but the other wellness programs, which you would assume they were trying to promote, it really makes it difficult to impose a significant carrot without endangering your affordability test, passing your affordability test.
Here we are on the affordability test. Again, some guidance that was issued on May 3rd relating to how do you pass the affordability test. And again, these comments relate to whether someone has, as of May 3rd, a wellness program. The first part of it is, do you provide a premium discount to non-tobacco users? And if the answer was yes, if you say yes to that, you can include that discount in calculating the affordability test. Now, if you have discounts for other non-tobacco related HIPAA compliant wellness programs, how do you consider those premium discounts? And again, it's consistent with what Scott just said. That discount can be considered in calculating the affordability test, but only in 2014. In 2015, you must assume the employee fails to receive that wellness program reward, and any premium discount is disregarded. So again, Scott, do you want to say anything further? I think you probably covered that.
I mean, it just, given the effort that's gone into structuring the wellness regulations and the thought that they were going to promote these programs, it seems that is contrary to their previous intentions.
Right. Okay, if we go to the next slide, this is going to tee up some of the conversation we'll have in the next few minutes about some special considerations. The failure to offer, when we talk again about you're required to offer minimum essential health coverage to at least 95% of your full-time employees and their dependents. If you don't, that triggers this sledgehammer penalty of the $2,000 times the number of FTEs minus the first 30. We've been through that in earlier presentations. But I think that it was worth mentioning again that the failure to offer coverage is not required to be inadvertent. That means that you can consider strategic exclusions if appropriate. And many of our health system clients are thinking through that when they consider their contingent, per diem, PRN nurses, and so forth. So let's get into some of these special considerations. Scott, you want to start that?
Okay, well, the first one is we've gotten a lot of questions of how do you handle part-time salaried employees? And the most direct answer is you count their actual hours. You have an employee that works 5 days a week, they work 4 hours a day, well, that's a 20-hour per week employee. You find some method of tracking or memorializing what they work. If this is an administrative burden, the regulations provide a equivalency that an employer can use for non-hourly employees. For each day they work, you can credit them for 8 hours a day, or for each week 40 hours. Now, those equivalencies basically are going to result in most of these part-time salaried employees being considered to be full-time employees, as a number of our clients have complained. So the question then follows, well, what if I have an employee that works 3 days a week, 10 hours a day? Well, you're now allowed to use an equivalency of 8 hours a day if that would materially understate the amount that they actually work, or not even materially, if it would understate. So you can't use the rule to change somebody from a 30-hour, 3-day employee to a 3-day, 24-hour employee and thus avoid an obligation to give them an offer of minimum value affordable health care. And then the next situation that we're getting a lot of questions with is seasonal employees. And again, you're allowed to use a good faith interpretation of the term seasonal in 2014. And generally that means that their job has a start and an end date for some particular reason. We've had some people suggest that they were going to use in a split job and have one person work the summer 6-month season and then somebody replace them for a winter 6-month season doing the same job. That is not a reasonable good faith interpretation, and really you need to have some reason for them, such as a holiday retail, a summer agricultural, something that reason that they're going to come in and then they're going to terminate. Now, we've talked before about the rules in which if you have a 26-week break and rehire somebody and they have no hours of service within that 26 weeks, you can treat them as a new employee. And the way this works with seasonal employee is when they are hired and you say, well, I can't reasonably determine that they're going to work more than 30 hours a week over my measurement period, and I'm going to consider the fact that they're going to terminate after 6 months and have 6 months of no work, you can effectively hold out a seasonal employee and never make that mandatory offer of coverage because they're always going to be within that measurement period as a new employee. But in that slide, you'll see that asterisk where we say they may work any hours. When they're hired, and if I'm looking at them and say, well, they might work 40, they might work 25, but then they're going to terminate after the season, and that non-service is going to average out to be less than 30, or I at least don't know that it's going to be more than 30, that's that determination. If I know that they're going to average over 30 regardless of the fact that they're going to have some months with zero service, then I'm going to have to make an offer of mandatory coverage to them, or minimum value affordable coverage to those employees if they meet that full-time employee definition. Next, we're going to talk about adjunct faculty and other employees which their hours are somewhat difficult to determine. The other example of this would be commissioned salespeople. The IRS rules give very little direction on this other than an employer must use a reasonable method for crediting their hours. And the example they use is adjunct faculty. If that faculty person has 3 teaching credit hours per week, you can't say, well, we're only going to credit them with 3 hours for purposes of this test. We have to find some reasonable method of capturing the amount of time that they're working, say, class preparation, office hours, what's necessary to actually accomplish their job. And that same reasonable method applies to people like commissioned salespeople. If they're traveling around and they're calling on customers, you can't only count the time that they're in that customer's office. You have to have some method of crediting them with hours of the time that's necessary to do their job. And then with teachers, those employees with school systems that have a standard employment break period, such as summer, there is a rule that the employer has to choose one of 2 methods as far as measuring their hours for purposes of full-time employee status. The employer can either exclude the employment break, basically measure only the time that they're actually working, or they can take the rate of hours that person performs when they're actually working and apply that same rate, whatever hours per week during the employment break period to get a result. Effectively, they're the same test in which you're really measuring the average hours worked over the time that they're actually working. And the reason this is interesting is there's been some commentary and concern that employees that are not in school system or educational institutions might be subject to something like this for any employment break period where they're not being paid, but they still have some employment relationship with the employer. So just keep that in mind as we wait for the final regulations on this stuff.
Next topic is kind of esoteric, and it applies mostly in, I'll call it the university or college setting. I suppose it's still thought-provoking in perhaps other ways because as relates to student workers, the issue is, are they really an employee of the college or university? And as we mentioned earlier, I talked about who is the employer, and that's really the essence of, having an employment relationship. What the student worker issue relates to is those students that are perhaps grad students working paid by some kind of stipend or grant program, but the exemption under FLSA, Federal Wage and Hour Law, basically says there's not an employment relationship if the individual involved is in more of a training mode where they're really probably providing less value to the organization than the organization is providing to the student. But in contrast, if you've got a student that's working, say, at the athletic facility, somebody said yesterday in a session, holding towels, or checking IDs outside the athletic center, that's an employee, and unfortunately, you probably have to look at counting their hours, which creates that administrative burden that many employers have objected to. But again, I think you can make you think about what is the nature of our relationship with this particular individual. Is it really an employee, or is it some other thing?
Okay. What we're using the hospital to illustrate is the strategic use of that 5% de minimis coverage exception. Again, an employer will not be subject to the $2,000 times all full-time employees if they offer coverage to at least 95% of their full-time employees. Well, the failure to offer the actual 5% does not have to be inadvertent. It can be purposeful. And still not trigger that nuclear type penalty. So what we've talked with some clients about, let's say an organization has 2,000 employees, well, that 5% is 100 employees. Well, just by inadvertence, they're pretty confident that they're not going to fail to offer to 100 of their full-time employees. So they're going to use a portion of that 100 employee exception to continue a class of not benefit eligible people. And essentially this is things like on-call nurses, PRNs, contingent employees, certain employees that their compensation package has never anticipated health benefits, and they've worked for that employer and are necessary for some reason, maybe patient care, staffing, workflow, something that they come in on call, perform a job, and they often work more than 30 hours, and it's a good relationship for the employer and the employee. Now, the reason that this sort of has worked is usually that per diem or contingent employee gets coverage through somewhere else, perhaps their spouse, and by continuing as not benefit eligible, they're allowed to continue, say, receiving benefits through their spouse. And most spousal carve-out provisions say that if the spouse is eligible for benefits with their own employer, they must take it. So you keep that status for your employee able to go on to their spouse's plan. There are two concerns with this. One, if the employee actually doesn't have coverage through their spouse and they go to the marketplace, the health exchange, and receive a subsidy, then the employer is going to be responsible for a $3,000 penalty for that employee. Mm-hmm. The second is by taking a portion of that 5% de minimis exception and making somebody not benefit eligible, you're reducing your margin of error in actually having an inadvertent failure to offer coverage. And if you go one employee over 5%, well, guess what? You've just triggered the $2,000 times all of your full-time employees penalty.
The next slide relates to COBRA, and I keep talking about the employment relationship. This is a little bit quirky, or at least it's not as evident. It's come up with different clients, but historically, if the employee terminated employment, obviously COBRA rights. Well, assuming you're an employer subject to COBRA, but I think probably everybody on this call is. And if somebody cut back their hours, reduced their hours, that would be a qualifying event, also triggering COBRA. With respect to the 4980H issue, it really presents the one of, has the employment relationship ended? So, for example, if we have an employee that goes out on leave, they've been a full-time employee, and they go out on leave, and we haven't ended the employment relationship, we may want to still end the employer paid coverage, or at least the heavy subsidy by the employer. That would still, trigger COBRA rights. But during the period the employee's on leave, it is possible that they're still going to be treated as a full-time employee, and we have the issue of the 4980H taxes. But in particular, if the employee is paying full COBRA costs, then that coverage would not be treated as affordable, and it's possible that it could result in a $3,000 penalty if that employee goes to an exchange. Practically speaking, it may not be likely, but it's possible. Fiscal year plans. A lot of plans are calendar year plans, and then hence January 1, 2014 becomes the magic date for application of this issue. But if you sponsor a fiscal year healthcare plan that was in effect on 12/27/2012, there's a transition rule, and basically the 4980H issue becomes applicable to the fiscal year that begins in 2014. So, for example, if you have a fiscal year plan of July 1 through June 30, the magic date for application would be July 1, 2014. Nonetheless, the reporting conditions to the IRS regarding employees who are covered by qualifying coverage, etc., still will apply beginning in the beginning of 2014.
Okay, now you have seen this this slide before about the payment of the PCORI, the Patient-Centered Outcomes Research Institute excise tax. The first of these taxes is due July 31, 2013 for the 2012 year. So we've talked before in earlier presentations, these taxes are paid in arrears. So it's the dollar per member is due this July 31. The thing I was just going to emphasize here is that if you are a self-funded employer, you're going to be using the IRS Form 720, and we heard yesterday from a CPA friend of ours that they've yet to revise the form for you to remit the tax. But the other point on this is that if you're insured, the questions have come up on this, is that if you're insured, your carrier will be paying this tax on your behalf. Some are building it into their rates. Others are just invoicing you on their premium statement. I'm sure some of you have seen maybe some of those line items being added to your premium billing. So again, I think the other question on this is that, well, how do I count? There are a couple different ways to count the numbers of members. There's a snapshot member. There's a 5,500 method. I guess the point on that is that if you need some further advice on the count method to use, our email addresses and phone numbers will be at the end of the presentation. Feel free to contact us and we'll send you some information about those counting methods. So going to the next one, this is what we wanted to say was that HHS did issue guidance on May 8th about the notice to all employees about the availability of a health insurance exchange or marketplace in their state. As you recall from the earlier presentation, we talked about how this notice was supposed to have been out by March 1, 2013. HHS delayed that, saying that we will provide some guidance in late summer, early fall. Well, that did come on May 8th, and Carrie and I will be talking about that a little bit more in a few minutes. I think the point to make on this is that just releasing the notice is probably not going to be something you'll want to do. It's going to cause a lot of confusion when you see it, and we're advising people to release proactive communications in advance of this October 1 notice requirement. So moving ahead into 2014, couple of points on this. In the middle of the page, I would say that when you look at the notice, and as we talk about that in a few minutes, I think it does corroborate what we have been talking about for some time, and that is you should expect interaction with the state exchange operators. They're going to be asking you for information about whether people were eligible for coverage, if they were eligible, but they did not enroll. I think you're going to want to be able to provide information to the exchange that they did waive. They were offered coverage, but they waived, or they were not offered coverage because they didn't meet the hours requirements. So again, I think you're going to be seeing where there is going to be this interaction required from your office and with the exchange operators. Another point maybe that is worth mentioning on the first bullet about the new individual mandate, something we've covered before, but it was an interesting thing that came up yesterday with an employer that has a fiscal year plan, and their fiscal year is July 1 to June 30, and they are ready to begin open enrollment now for that July 1 year. And so they have a lot of younger people. Many of them have historically waived coverage, and so they're wanting to think about in their open enrollment communications quickly reminding them that they do have this individual mandate that's effective January 1 of 2014. So if they waive coverage in this open enrollment that's about to begin for July 1, 2013, they won't have another opportunity to enroll in their employer's plan until July 1 of 2014. But they're going to have this individual mandate applicable to them January 1. And so they're subject, if they don't enroll in the exchange for January 1, they're going to incur this $95 per person, the greater of $95 per person or 1% household income tax. And Scott Newsom and I were talking about this yesterday, that when they go to file their 2013 taxes in April of they file their 2014 taxes in April of 2015, they're probably going to be asked to certify whether they had coverage in each of the months of 2014, and if they didn't have coverage from January to June 2014, they'll probably have a reduction in any income tax refund that was due them in 15, correct?
Right. And so, in reality, the attendee was concerned that she was going to have some angry employees, and we said, well, the best you can do is communicate to them what their obligations are, but if they don't listen, it will be a year later until they actually incur that cost.
Right.
But only if they have a refund.
Right.
Right. Again, the only way that this individual tax is collected is from tax refunds and ultimately Social Security payments.
So,
moving ahead into 14, again, you've seen this type of slide before about the transitional reinsurance program fee. I think it's worth mentioning again that this fee will be paid on an annual basis. It looks like it will be paid probably in January of 2015. It's actually, I think that the calculation is going to be done as of November 15th of 2014. They then give you, I think, 30 days or 31 days from that point to pay it. So it could be physically paid in January of 15. But the point is, when you're developing your benefit budgets for 2014, you're going to want to include this fee. The other point on this is that in Ohio, as an example, this is intended to be a state-based program. We still don't know if Ohio intends to establish its own transitional reinsurance program or whether they will, as they did with the exchange, default to HHS. If HHS runs the exchange, or excuse me, if HHS runs this transitional reinsurance program, then the maximum that they can assess, even an insured plan, is the $63 per member. The point on this is that if Ohio were to establish the transitional reinsurance program fee, they could assess an additional fee on an insured plan. They could not assess an additional fee over and above the $63 on a self-funded plan subject to ERISA, but they could assess more than $63 on an insured plan. Again, the last point being, too, is that unlike the PCORI fee, if you're self-funded, you'll be paying that PCORI fee using IRS Form 720. In this case, this is not an excise tax. You could have your TPA pay the fee for you if you chose to do that, and they can invoice you. Otherwise, there'll be a mechanism for you to remit this to HHS directly. The next slide we'll just talk about, for those of you that are insured, and there's some of you on the line that are, again, reminding you that in 2014, it's the insurance company's turn to pay excise taxes on their sales. The pharmacy, the drug makers, paid excise taxes on their sales beginning in 2012. Medical device makers are paying excise taxes on their sales beginning this year, 2013. Well, next year, the carriers begin paying excise taxes on their sales, their premiums written in the preceding calendar year. And Anthem, MMO, and others are saying this is probably going to be 2.4% or more of premium. And so our point to you, if you are insured, check with your carrier on how they plan to pass through this tax to you. Obviously, they're not going to pay it. You will ultimately pay it as their contract holder. But one of the carriers has indicated that they plan to put this on the group's monthly invoice, just as they are with the PCORI fee, and others are saying that they're going to just build this into the renewal rates. But check with your carrier to see how they're handling it. In 15, this has kind of been a sleeper item. Non-grandfathered plans in 2015 are required to limit their cost sharing on medical and prescription drugs on a combined basis. That cost sharing is limited to the same out-of-pocket maximums that are in place for high-deductible health plans with HSAs. Last month, or earlier in May, they announced that the limits in 2014 for that cost sharing for HSAs is $6,350 for single, $12,700 for family. We will not know until a year from now what those limits in 15 are going to be. But the point on this is that if you have a separate medical administrator, separate and apart from a pharmacy benefit manager, in 2014 as a transitional year, you can have this cost-sharing limit applied separately to your medical and to your prescription drugs. But the point is that in 2015, the rule is that cost-sharing limit will be integrated with medical and prescription drugs. So you're probably thinking, well, that sounds like it would increase my claims cost. And you're right, it will. And in consulting with other actuaries, we're thinking it's going to probably be in the range of 3.5%. 3.5% increase in your medical prescription drug claims cost in 2015 as a result of this limit. The next thing to think about, and we've talked again about this in earlier meetings, we do have this I think, rather ominous reporting requirement under the new Internal Revenue Code Section 6056 that will take effect in January of 2015, where you're going to be disclosing in some kind of a super annual information return to HHS, the number of FTEs that you have each month. You're going to be certifying that the coverage that you offered, at least one of the plans that you offered in that minimum value test, that the contributions that you offered under at least one of your plans were affordable and so forth. So you'll have this fairly significant information return. The odd thing about this is that as part of this reporting requirement under 6056, you will, by January 31 of each calendar year, furnish to each of your full-time employees a comprehensive written statement containing all the information basically that you submitted to HHS. So we'll be standing, by to provide more guidance as it's released on this, but you need to be thinking about that. And then, of course, we have the Cadillac tax that's still looming out there in 2018. As we do our claims forecast and funding projections for 2014, we are updating those. We're trending forward and showing our clients where they will stand if they make no further changes in benefits, where they stand in 2018 relative to these thresholds. So that gets us into the planning considerations, and we've talked a little bit about this before, about we're not suggesting that you eliminate coverage for spouses, because even though you're not legally required to offer coverage to spouses, that's going to probably wreck your brand and employment value proposition. But again, what we're talking about is look at the subsidies that you're providing to spouses, look at the subsidies that you're providing to dependent children, and recalibrate those if necessary, considering your current business situation. Again, just emphasizing that these affordability requirements apply only to single full-time employees, don't apply to part-time employees, they don't apply to full-time employees with family coverage. The other thing on this I think is worth mentioning is that when we talk about building your budgets for 2014, think about to what extent your health benefit eligible full-time employees have waived coverage. At Findley Davies, as an example, we have about 117 benefit eligible employees. 23 of them have waived coverage because they have, we will not allow people to waive unless they provide proof that they have coverage elsewhere. But we don't know what's going to happen to those other employers' plans. It's possible that some of those, if they are relatively small, they may be deciding, because of the pay or play decisions that they're making, that they may decide to eliminate their plans, send their people to the exchange. If that were to happen, some of our people that are covered under spouses' plans may come back onto our plan. And in talking with other consulting actuaries, we're estimating that as many as 25 to 33% of people who have waived coverage may come back onto their employer's plan. So you need to think about that. Look at your waivers. Think about this and build that into your budgets for 2014. The other part of this, too, is that we've talked about before. Consider offering more of a minimum value or bronze plan in conjunction with some type of a core buy-up strategy. We're getting lots of remarks here in the last couple of days, Scott, about the Wall Street Journal article. There's a Forbes article that came out yesterday on offering what was referred to as skinny plans that deliberately do not meet the minimum value test. And I think some of these groups like Home Depot and others are betting that not too many people will wind up going to the exchange and pay the premiums on the exchange, and they will avoid penalties that way. Do you have any comments about that?
Well, yeah, over the last couple of days we've seen these articles, and again, if it doesn't meet the minimum or the affordability test or the minimum value, there are potential consequences. And I have some skepticism over the effectiveness of this skinny plan strategy. It seems there hasn't been a lot of detail in the articles, but to me it sounds much similar to the, I guess, the thinking prior to the Supreme Court is certainly going to strike down the Affordable Care Act, and therefore I'm not going to apply. So as more detail emerges, my guess is we're going to see that the strategy sort of folds. But going back to the idea of a minimum value bronze plan, that's probably much less than what most employers are offering. And I think you need to first explore what the cost to your business would be in complying before you start thinking about alternative strategies to not comply and potential impact.
Just a couple quick comments before we get into the communications aspect. We're still looking for final wellness rules. As you remember, these were proposed back in November by the Employee Benefit Security Administration. They were designed to apply to both grandfathered and non-grandfathered plans. Many of the comments that were submitted before the January 25th deadline revolved around reasonable design. And I just wanted to update you on something that just occurred. The American Benefit Council, which represents primarily large employers, did write to President Obama on May 10, and if anybody wants a copy of that letter, you can email me and I'll be happy to send that to you. But they were talking about their concerns over these proposed rules that these requirements for a reasonable alternative standard would apply even when the reason that the individual did not meet the particular goal, and I'm not going to read all this on the slide that you're seeing, was not medical in nature. What they were concerned about is that these proposed rules could lead to employers having to develop individualized means for participants to obtain the rewards. They felt it would be administratively cumbersome and make the wellness programs more complex. So I'm not going to take more time up on this, but if you want a copy of that letter that went to President Obama, email us. The other thing I wanted to just mention real quick was that there was also May 8 testimony before the EEOC. American Benefits Council and others were testifying about their concerns over the legal uncertainty of applying the ADA and GINA rules to wellness programs. As you're probably aware, EEOC has been slow to embrace these HIPAA rules that IRS, DOL, and HHS had all signed on to, that EEOC has been out there challenging employers' wellness programs to the extent that, questioning whether they are, quote, voluntary or not. So the purpose of the testimony was to encourage EEOC to work with the other regulatory bodies so that the employers can have more rely on a consistent approach. So I think our advice continues to be that if you're setting up incentives and things of that sort, be careful and consult with your attorneys to make sure that they're going to be fully compliant. So with that, I'm going to turn over to Carrie with some quick tips on communications basics.
Thanks, Bruce. So once you figure out what you're going to do with your plan design, it's probably going to be go time for communications. What we're recommending to all our clients, as much as you can, start planning for open enrollment communications early. So some best practices for what we've seen work really well around how to communicate are as follows. If you can, you want to educate your leaders. The link between supervisors and employees communicating is the leading indicator on engagement. So you want to make sure that your supervisors just understand what questions may be coming their way and are ready to answer those questions, or at the very least direct people to where they can get some answers. This year we think that as the exchanges open up, employees are going to get a bunch of mail from the carriers and are going to start to have other opportunities for enrolling in a health plan. So it's more critical than ever, if you haven't already, to develop a brand for your communication. So a color scheme, a logo, whatever it may be, so that people understand that this information is coming from you, the employer, not the carrier. So in the past, if you listed the carrier name as your medical plan brand, we would recommend that you attribute it to your own company. You now more than ever want to emphasize the value of your benefits. A lot of our clients do this through total compensation reports, where you personalize the value of the benefits, the value of their pay, so they get a true picture of what the value of working for your organization is. I can't emphasize this enough. Healthcare reform is complicated. Everybody on the phone call knows this. You need to make it as simple as possible for your employees. Target a 5th grade reading level if you can. There are tools in Microsoft Word that allow you to test that. But, you know, if at a first pass you have somebody read it and they have no idea what you're talking about, it's too complicated. So tell them what they need to know, what they need to do, and why it matters to them. Those are sort of the 3 tests. And that call to action is critical. Employees need to hear things 9.3 times now to have it sink in. So if you're telling them something that's nice to know, not need to know, it's probably not going to really register. So keep it simple, repeat it, make sure they understand what they need to do and why. And more than ever, it's really important to make sure that people have a resource to understand where they can find the materials. So even if it's just a bulletin board in HR or a corporate intranet, if you can post materials where they can get back to them, share them with their spouse, that's really important. Okay, so moving on to the exchange notice. The model notice was released. The deadline given is 10/1. What you don't want to do here is just send this out with no context. You want to take the opportunity, if you're doing a mailing anyway, draft a cover letter. You know, if you can't get out ahead of it, what we're really recommending is, like Bruce said, you get out ahead of this in the next couple of months. Send a note to your employees that they might expect to see some mailing from the carriers, that they might expect to hear something about this. But at the very least, if you can't do that, put a cover letter in with this exchange explaining that this is, you're required to provide this, you still offer benefits, that you recommend employees take a close look at your benefits, that they probably provide the best value.
And you've drafted a cover letter.
Yep.
That you're planning to use on a couple groups.
Yeah. Yep. So we can help you with those examples. And again, the key here is to keep it really simple and let employees know what they need to do and why. Let's walk through just really quickly what you need to do for this exchange notice. So we have to provide, employers have to provide the name, phone number, address, contact information for who they recommend for more information. But ironically enough, HHS just is giving healthcare.gov as their contact information.
Right. So it looks like on this particular slide, it looks like we're going to provide our contact information, our contact's name here. Mm-hmm. We'll get on the next slide that gets into more detail. But healthcare.gov, they're not providing any more contact information from HHS than that.
Yep.
So, very strange.
Bit of a double standard, if you will. So here on the next slide, Part B is where you actually designate the person for HHS to contact with benefits. In most organizations, this will be your benefits person, your HR department. And this is if an employee applies for the exchange and HHS needs to get in contact with you for further information about your benefits, this will be the person who can answer those questions.
Right. So when we first looked at this, we're looking at that item number 10, who can we contact about employee health coverage at this job? And we thought about this, and we, I think, are all on the same page. We means HHS. Mm-hmm. So this gets back to our point that you will expect to have interaction with the exchange operators, because this information will be taken by your employee to the exchange, and they will be contacting you about the coverage that you offer or didn't offer.
Next, the notice has you indicate to whom coverage is offered and whether it meets the minimum value test and if it's affordable. So you need to list the eligibility for your employees, the dependent eligibility, and check whether or not you meet the minimum value standard. So for this, you should probably just use the language that's reflected in any other open enrollment materials. I'm sure that most of my clients do define eligibility, so just try to keep it as simple as possible.
We have two attorneys in the room, and this question came back yesterday, that if I check that box at the bottom that says my coverage meets minimum value and the rates are affordable, what happens if they aren't? Do I incur any fines or penalties for having lied to HHS? I mean, these questions were asked yesterday. Scott, do you have any? Scott's 1 and 2. Do you have any comments about that?
Don't know right now. I don't think it's. I guess you want to make sure you have a reasonable belief that is accurate, but.
Right. But those are questions that your peers are beginning to ask.
And we're going to have to make sure we get answers to that by 10/1/2013.
Right.
Yeah, I think the reasonable belief, though, would be important.
Yeah.
Yeah. It's hard for me to imagine, actually, that anybody would really dishonestly answer a question, except consciously dishonestly answering the question.
So the next section on the exchange notice is optional for employers, and we think that most employers choose not to fill this out. It makes the exchange notice personalized, and in our opinion, there are better ways to do personal communications that really get to the value of the plan. So this is an optional section. A lot of employers, most employers, will not fill it out because it asks for information related to the individual. That's it on communications.
Yep. We have some questions that have come up. One question is, who pays the excise tax on the Cadillac plans? The employee or the employer? We are a government. Is it the employer? Do we still pay? So I think in most cases a company never really pays a tax. They probably pass it on to the form of the employees in the form of lower wages or try to pass it on to their customers. But in the case of a government, it's our understanding that the government plan would pay the tax.
Yeah, I think the employer pays and has the liability. I mean, I agree with you. Economically, you would think that it's going to, and I think that's the point of the Cadillac tax, is to make the employer and the employee evaluate where do they want to spend their dollars and perhaps work towards a plan that is more economical and arguably more cost-effective and efficient. Not that necessarily you're trying to cut coverage as much as cost-effective and efficient.
We had a question about interns. Do we think we've addressed that with the student workers, or do we want to say anything further about that?
I think summer interns, you treat them as seasonal employees. You know that they're going to terminate employment. You can use those zeros for the period after their employment to make sure that over that measurement period they're not going to meet 30 hours.
Okay.
Yeah. Now, however, occasionally an employer will call somebody an intern, and then they'll employ them 12 months.
And then you have to just count them as a variable hour employee and count their hours.
Yeah, picky point. But.
And we have another question, maybe along these same lines. Where do you see 1099 employees?
Well, it's back to who's really the employer. And sometimes, groups, entities will say, no, that person's an independent contractor. But again, when you really analyze the facts, they're likely not an independent contractor. But one of the key criteria of being an independent contractor is that you're rendering services to more than one employer. So the people in this room, Bruce, Scott, and Carrie, we're certainly not employees of our clients because, we have a bunch of different clients. But the independent contractor issue is, begs the question of who's the employer, but generally speaking, the individual is rendering services to more than one employer. They're probably an independent contractor in your state, so disregard them.
Let's go back to the penalties. We're getting a question as an example. If one employee goes out to the exchange, there's a $3,000 penalty. The first 30 employees exempting does not apply, ? What if there are 5 employees that get insurance on the exchange? Is the $3,000 due on all 5 with no exemptions?
Well, and there's a previous question about whether or not they have to get a subsidy too.
Yeah.
Again, somebody has to get a subsidy or cost-sharing reduction before any penalties apply,
Right.
Either the $2,000 per employee or the $3,000. The $3,000 does not have any 30-employee reduction. It is just simply what employee goes to the exchange and gets a cost-sharing reduction times $3,000. So just keep that in mind that if an employee waives coverage and then goes to the exchange and buys, if you've offered them minimum value affordable health care, there is no penalty. There was some question in there about full-time equivalent employees and full-time employees. Full-time equivalent employees only count towards applicable large employer status. So in the way a equivalent employee is calculated is you take all of the hours of your part-time employees per month, add it together and divide by 120, that's your equivalent employee. That's the only thing that counts for as applicable large employer status. all these penalties are actual full-time employees, which are 30 hours more per week or 130 hours more per month.
We want to look at answering the COBRA questions.
Yeah, let's answer this one though first. We've got someone, if someone is on call and paid $1 per hour while on call, probably paid that for carrying a pager, I guess. Do you believe those hours would count as hours worked or hours credited? This is something that's come up with our hospital clients before with the contingent and PRN people. So go ahead.
Honestly, I keep needing to research this just to check, but I think the answer is going to be no, because I don't think they're rendering any service. They're just on call.
Right.
But I think the answer is as simple as they're not rendering service.
Mm-hmm. Do you want to go back to that COBRA question that we had?
That's down, and it's if an employee goes on COBRA, will automatically be over the 9%. Well, the point I was trying to make earlier is if an employee is on COBRA and we still have an employment relationship, during a stability period, they may be treated as a full-time employee for purposes of the 4980H tax. And in that we've offered coverage, I think the only tax applicable is the $3,000 tax. And yes, it may not be affordable, but as Scott referenced a moment ago, in and of itself, that's not a problem. It's only if they go to the exchange, get the exchange, and get a subsidy or premium reduction.
Okay, here's the question. I have a pool manager that works Memorial Day through Labor Day. During that time, she works full-time hours, 40 hours per week. Do I have to offer her coverage, or is she a seasonal employee not entitled? So that's, 4 months. That would be a seasonal
employee.
Sounds like seasonal. You'd want to establish a measurement period of probably 12 months to ensure that you had an adequate measurement period to reduce that 40 to below 30 over that period of time.
Yeah, and what a seasonal employee might be with respect to these issues is not really defined, but Scott alluded to it earlier, and I think it's really probably in a very gross general way, limited duration and to meet a particular staffing need for a particular period of time.
Right.
So like retail around Christmas, that seems so obviously seasonal. And I think the pool thing seems obviously seasonal, limited duration, and obviously, at least here in Toledo, we're not going to have the pools open in December.
If an employee goes on COBRA, it will automatically be over the 9% because the former employee is likely not earning an income. Does that mean my company will have to pay a penalty? Well, it depends. Are they on COBRA because they terminated their employment? Then the employer has no obligation to offer minimum value affordable care to non-employees. But if they transition from a category of employee that has benefits to not benefits, well, during their stability period, they are a full-time employee for purposes of these rules and are entitled to a minimum value affordable offer of health care coverage.
We're going to try to respect your time. We have other questions that have been posed, and I think what we're going to do is we'll spend time after we sign off a FAQ, and we'll post that. There's been some questions on here, multiple questions about has this been recorded? The answer is yes. And will that recording be available online? And it is at FindleyDavies.com. We will be also posting these slides later on FindleyDavies.com as well as the FAQ. So, but again, feel free to contact any of us if you do have some other questions that come to mind. We'll do our best to answer the others that have been asked today. And we again thank you very much for participating. And as further guidance is released, we will plan a future WebEx and keep you all informed of that. Thanks again. Bye.